There's no hiding this time. Working on it. Double click on it.
Can you hear us? You don't hear anything at all?
You're static.
We're
talking.
Hello, hello, hello. Hello, hello.
Oh, I can hear.
Can you hear it now?
Can you hear us now?
Yeah.
It was delayed. I heard it. I'll grab it for this meeting.
What?
It's up, life.
Good evening. My name is Harry Darnell. I'm a Salem Foods official. For the record, it's 5:30 on Wednesday, April 8th, 2026. This evening, we have one hearing on our docket. This hearing concerns an application for a conditional use permit for a short-term rental on property zone residential located at 1115 Little John Loop Northwest. The applicant is Lena Davidson.
Here.
Is that correct? Lena?
Lena.
Lena. Another E in there. This is case number CU 26-04. The approval criteria in this case can be found in section 240.050 parentheses large T, capital D, parentheses 1 through parentheses 3 of the Salem Revised Code. And the staff will go into more articulation of what these criteria are. Before we actually get into the testimony portion of the hearing, I'd like to describe the rules that we follow, the procedures. These hearings are characterized as being quasi-judicial and de novo. Quasi-judicial, that means there's certain due process rights that are associated with the hearing. Right to notice, the right to testify, a right to an impartial decision maker, a right to a final written decision with findings of fact and conclusions of law. De novo means that new evidence and argument is allowed as long as it's relevant to the approval criteria. The evidentiary rules that we follow aren't the same as you'd see in circuit court. They're a lot more relaxed. Evidence that is admissible in these hearings are such that would be commonly used by a reasonably prudent person conducting their daily affairs. Testimony and argument and evidence needs to be directed towards the approval criteria. I don't consider statements that are not relevant or material to the approval criteria or overly argumentative. It's important to note that you need to raise substantive or procedural issues for the close of the hearing in order to preserve your right to raise those issues on appeal to the Oregon Land Use Board of Appeals. Now, my decisions can be appealed to the Salem Planning Commission. So you don't raise those issues before the hearings official, you'll have an opportunity to raise those issues for the Planning Commission. But ultimately, you need to raise those issues at the local level in order to preserve your right to use those on your appeal to the Oregon Land Use Board of Appeals. Also, failure by the applicant to raise constitutional or other issues relating to the proposed conditions of approval with sufficient specificity to allow other parties and the decision maker to understand the nature of your concerns will preclude your ability to raise those issues, asking for damages at the circuit court level. The burden of proof on each fact or position lies with the party asserting that fact or position. The ultimate burden lies with the applicant to show by a preponderance of the evidence that all approval criteria have been met. The record in this matter includes the application and supporting materials, the staff report, any written or oral testimony received at this hearing, and if the record is held open, any written material submitted during the open record time. If you want to ensure that your items have been considered by the hearings official, make sure you raise that in testimony and present the material to the hearings official at the hearing. By statute, you have the right to request that the hearing or that the record be held open an additional 7 days. Now, if that request is made before the hearing closes, then we talk about how long the record needs to be held open, because we need to make sure that all parties have an opportunity to review and comment on any new evidence that's placed into the record. Ultimately, the applicant gets the last ability to summarize or address the evidence in the record. You will also have the right to request a continuance of the hearing. That's another hearing. That matter is discretionary with the hearings official. You need to demonstrate that merely holding the record open for a certain period of time isn't adequate to address your concerns. In terms of testimony, we electronically record the testimony. We ask that those who testify use the podium. There's a microphone there, and that's the best way to pick up your testimony. And also that you state your name prior to giving your testimony. And that way, if we have to do written record of your testimony, you can attach your name to your testimony. We begin the testimony portion of the hearing with the presentation of the staff report. Following the presentation of the staff report, there'll be the opportunity for the applicant to testify in support of the application, and then any representatives of the applicant, and then others in the audience to also may wish to testify in support of the application. Then there'll be a opportunity for the neighborhood association to offer testimony. And then people that wish to testify in opposition to the application. Finally, there'll be an opportunity for those that would rather not be identified as being either pro or con, have questions or would like to make a statement, they'll have an opportunity to testify. At the conclusion of all that testimony, I'll ask staff if they wish to address any of the comments that were raised or questions. And then finally, there'll be an opportunity for the applicant to offer rebuttal or summary testimony. Any person who has standing, i.e. has testified either in writing or orally, may appeal my decision to the Salem Planning Commission. You have 15 days to do so after the mailing of my decision. Appeals before the Planning Commission are de novo, which means you can raise new issues of law, new evidence that wasn't raised before the hearing's official. Finally, the Salem Revised Code requires that the decision maker in these matters be impartial. In that regard, I'd like to indicate that I've had no ex parte contacts or any conflicts of interest of which to declare. Ex parte contact is where there's a communication between the decision maker and a party to a matter the decision maker is deciding. That communication occurs outside this public venue and goes to the substance. If those communications occur, they need to be disclosed and a determination made whether or not they have prejudiced the decision maker. Conflicts of interest have to do with whether or not my decision would benefit myself, a family member or household member, or business I'm associated with financially, or whether my decision would prevent a financial detriment to myself, a family member or household member, or a business I'm associated with. This time, members of the audience may challenge my impartiality, and you can retain the ability to do so throughout the hearing. If there are no challenges, I would ask for the staff.
All right, good evening. I'm Caroline DeBruin, planner with the City of Salem Planning Division. We're here to discuss conditional use permit CU 26-04 at 1115 Little John Loop Northwest. And before I begin, I'd like to request that this presentation, staff report, and all comments received be submitted into the record.
So received.
As I mentioned, this is a request for a conditional use permit for a short-term rental within an existing single-family dwelling. Property is an existing single-family home in the West Salem Neighborhood Association. It is surrounded by other RS single-family residential zoned properties. So it's in a mostly low-density single-family neighborhood. At the time of submittal, the applicant indicated that the property is not part of a homeowners association. Based on the recording plat, the subject property appears to be located within the Summer Park Homeowners Association. The Salem Revised Code requires that notice be sent to any active or duly incorporated HOAs involving the subject property. Notice of the hearing was sent to the HOA and a comment was received. Therefore, staff does not believe that procedural error occurred. The property is a flag lot that takes access off of Little John Loop Northwest and is encumbered by 2 access and utility easements. There are no exterior changes or development proposed, simply for a short-term rental within the existing 2,188 square foot 3-bedroom dwelling. That is also improved with a 436 square foot garage. Looking at the approval criteria for a conditional use permit, the first one is that the proposed use is allowed as conditional use within the RS zone. Short-term rentals are allowed as a conditional use in the RS zone. Second, the reasonably likely adverse impacts of the use on the immediate neighborhood can be minimized through the imposition of conditions. A number of conditions inspired by the accessory short-term rental special use standards have been recommended to limit the adverse impacts to the immediate neighborhood. Finally, the proposed use will be reasonably compatible with or have minimal impact on the livability or appropriate development of the surrounding property. With the imposition of the recommended conditions of approval, the proposed use will be substantially similar to other single-family uses. And in essence, the property will operate as any other single-family residence. Looking at the recommended conditions of approval, firstly, the maximum number of guests in the short-term rental shall not exceed 6 persons. For the purposes of this condition, children under 12 years of age do not count. Second, the short-term rental shall be rented to only one group of guests at a time, so no concurrent bookings. Third, the use of the short-term rental the use of the short-term rental shall be limited to lodging uses, no commercial activities, fundraisers, events, etc. Fourth, the use of the short-term rental shall not generate noise between the hours of 8 p.m. and 8 a.m. in accordance with City of Salem noise ordinances. And finally, bicycle parking spaces meeting the development standards outlined in the code are required. No comments were received from any public agencies or the neighborhood association. 1 comment was received from the homeowners association, and 4 comments were received from members of the public in opposition of the short-term rental. Finally, staff recommend that the conditional use permit be approved with the recommended conditions of approval as outlined in the staff report.
Now's the opportunity for the applicant and applicant's representatives to testify in support of the application.
Oh, sorry. I'm Lena Davidson. I'm the owner along with my fiance and that's my 3-year-old. Sorry about that. We own the property at 1115 Northwest Little John. We purchased it with the intention of it being a short-term rental. The seller did not disclose that it was part of any association. That is specifically why we purchased this property. I do property management and have done so for over 10 years, a lot of which is long-term rentals. I've been doing short-term rentals as well for the last couple of years. And I would say overall, the condition that our long-term rentals after being stayed in by long-term tenants is far inferior to our long-term rentals, where the income that's generated from there exceeds the amount that you get from a long-term rental. Therefore, the owners tend to keep those up in a higher standard, and including all the interior furnishes. Usually there's a lot of amenities that go along with that as well, that requires a significant investment from any of our homeowners. I'm surprised that there were any objections to our turning this into a short-term rental. So I look forward to seeing what you guys' comments are and feedback, and if there's anything we can do to, subside your guys' concerns. Appreciate it.
Some questions. Have you ever actually operated a short-term rental yourself as opposed to manage them?
So that is operating a short-term rental, but this will be the first that we personally own. Our management company, I run that short-term rental division. Yeah.
You've, I assume, read the comments that were submitted regarding the easements that impact the property.
I did not see those, sorry. There was a lot of back and forth between me and I believe Celeste and the homeowners association attorneys. And I felt that it got to a point where I really needed to have an attorney respond to them because we were not aware of the homeowners association to begin with. Yeah. I'm at an unfair advantage there.
Many of the previous applicants for short-term rentals have installed security cameras
Mhm.
to,
Sure.
so they could observe what's happening on their property.
And we do have some that we manage that do that, not all, but it's certainly something we could consider if that was something you guys
On
proposed.
this particular property, do you have security cameras or do you intend to?
We do not currently have security cameras. That's something we have discussed. But we have not installed any to date.
The question still lies there. Are you going to install it if you have your conditional use permit?
We may,
You may. Okay, thanks.
any other question?
No.
Thank you.
Are there others who wish to testify in support of the application? Are there representatives from the neighborhood association?
For the record, my name is Stephen Anderson, Land Use Chair with the West Salem Neighborhood Association. Before I start, I just want to clarify one thing in the staff comments tonight. We did not provide comments because the notice we received from the city said comments were due the day after the staff report. So there was a process error there, so we did not comment ahead of time, so I apologize for not having things in the
Your
record.
testimony has the same weight.
Okay. So, Your Honor, regarding this conditional use at Little John Loop, the Neighborhood Association asked for condition number 4 that it be revised to conclude definite noise levels not to be exceeded at the property line. We understand that the city code has been cited, but we think that that should be part and parcel to the condition, as all other conditions have specific parameters for them. In addition, we asked that a 6th condition be added, which would raise, it meets the criteria that you cited, section 240.005 parentheses D2. And this condition would read as follows. Condition 6, the conditional use permit shall be for the duration of the ownership of the subject property by the applicant. We understand in past cases, staff has claimed that this condition does not comply with section SRC 300.820 parentheses A2. However, they have provided no evidence supporting this claim outside the conditional requirements that you cited tonight as approval criteria. We asked the hearing officer to make findings of fact in the decision to adopt this conditional number 6. We will provide evidence tonight supporting that position, and those will be directly related to SRC 300.820 parentheses A2. First, the review authority shall not impose any permanent condition which would limit the use of the subject property to one particular owner, tenant, or business. This is in direct opposition to the criteria cited tonight, which reads as strict. And this is a strict reading of staff, which suggests that there might be a conflict here in the code. Because SRC 240.005 parentheses D2 says the reasonably likely adverse impacts of the use of the immediate neighborhood can be minimized through the impositions of conditions. As was reported here in the staff report, there are 5 conditions already proposed. Now, as we looked at this short-term rental, this is an activity on a property which is subject to the licensing requirements that was cited in this opening of this hearing. No action affecting the underlying land guarantees to the property. A key decision point here is the use of this licensing of at the property versus the use of the properties. This is the conflicting language that hasn't been clarified or with evidence from staff. We argue that the use of the short-term rental refers to the activity on the property, which is subject to the licensing requirements, not the actions affecting the underlying land use granted by the property or for the property, for example, zoning and other restrictions. This is a key distinction. Otherwise, the two codes are in direct opposition. And one cannot be enforced without affecting the other. This presents a huge mess for the hearings officer. Going on, our condition 6 is included to minimize the likely adverse impacts on the immediate neighborhood as was specified in criteria 2 here on the screen by staff, as are the other 5 proposed conditions. From the CU 2505-925 Terrace case, the hearings officer, and I believe that was you in this case, on your finding number 10, page 5 on July 29, 2025, in your conclusion supporting your argument for our request for condition shifts, the statement was, this was explained in the findings that it complies with SRC 240-005(d)(2) as reasonable and negating a reasonable likely negative impact on the short-term rental on the immediate neighborhood per the applicable licensing requirements, including the short-term rentals under section SRC chapter 30. Therefore, all 5 conditions proposed by staff and the one requested by the neighborhood association fall under the criteria 2 of the licensing requirements proposed by staff. Here's where the rub comes in. So there are 6 conditions. Staff only claims that one doesn't meet the criteria, and they go to that 380 standard and say it doesn't comply with that. If that is the case, then the other 5 do not meet that criteria either, because those are 5 conditions that are permanent for the site. And so you would have to negate all 5 of those conditions, including not allowing ours. That sets up a dilemma. Who proceeds here? And it goes back to the definition here with use of a condition and licensing requirements and saying that this is not a permanent use. That has not been sorted out in the testimony or in the information provided in the staff report. Staff claims makes no sense. All proposed 6 conditions meet the requirement of SRC 240-005(d)(2). I'm reading from the bottom paragraph. Either all are allowed or are not allowed. If this is not allowed, the conditional use process is a mess, not functional and impotent licensing processing granting a conditional use permit. A more realistic on page 2 and likely interpretation is these 2 apparent conflicting codes is that SRC 300-820(a)(2) for city short-term rental process is a granting of a permit as part of the licensing process that authorizes a specific activity for the use on the property with conditions to protect the surrounding neighborhood. It does not impose a permanent condition affecting any current authorized land use now or in the future. Note, conditional means that the activity is subject to, implying, or dependent upon a condition that cannot be imposed, can be imposed for a specific time. This is supported, our position that condition 6 can be applied with the other 5 is supported in that the City of Salem's Public Works Department has limited fill permits so that they are terminated with the sale of the property. I have personal knowledge and worked on the case. We have an email from the Deputy Director of Public Works stating that fact that we can provide if so desired. So Public Works does terminate permits, fill activities from one owner to the next, contrary to the opposition here. Additionally, other communities have this provision that terminate short-term rental permits at the sale of the property. So this interpretation is likely and reasonably supported by evidence in other communities and within the departments currently within the City of Salem. Now, the second sentence that does allow the imposing of conditions. So if we look at section 380-820 in total, which says permanent conditions may be limit subject property as to use, but shall not be so restrictive that other occupants who may devote the property to the same or substantially similar use would be unable to unreasonably comply with this condition. So the question is this condition reasonable or unreasonable? Clearly, section SRC 300-820(a)(2) does include provisions to include a permanent condition. given it would not be unreasonably to comply with. Staff has given no evidence that having a new owner obtain a new conditional use permit is unreasonable. This could imply that obtaining the first permit may be unreasonable. That aside, our position is that the first argument that we made has provided sufficient evidence that the proposed condition 6 complies with both SRC 240.005(d)(2), the criteria specified in the opening of this hearing as being applicable and what has to be looked at, and SRC 300.820(a)(2). Staff nor the applicant have met the burden of proof to say otherwise. However, we assert that our condition 6 is not unreasonable and in all instances complies with SRC 300.820(a)(2), and it should be adopted by the hearings officer. Evidence supporting condition 6 as being reasonable is the City of Salem Public Works policy to terminate fill permits from one owner to the next, that other communities have this requirement, and the language of the code is not specific defining what would be unreasonable to comply with. Please note that there is a LUA case on this decision saying that the regulatory authority has to have a specific definition as to what is reasonable and unreasonable to enforce this condition. That does not exist for SR 300.820. Therefore, the West Neighbors Association asked the hearings officers to approve additions of our proposed condition 6. It complies with SRC 240.01, SRC 240.005E, and SRC 368.20(a)(2) as presented in our testimony. What we are asking is reasonable to negate negative impacts of a short-term rental on the immediate neighborhood. Basically, there are 5 conditions proposed under the criteria. We're asking for a 6th. For your decision in the Terrace case, you said that it does meet that requirement. If we are to say that 380 supersedes, then all of those conditions have to be terminated and there's no provisions to meet the requirement 2. It's impossible to meet requirement 2. That's your condition. So simply, we're asking for a condition 6 that just says when the property is sold, permit terminates. Public Works does that, other cities do that. It's reasonable and it meets all the requirements of the sections cited here. If you have any questions, be happy to answer them. Other than that, thank you for your time. Hopefully that gives you enough information to kind of scratch your head and sort this out.
Are there those who wish to testify in opposition? Are there those who wish?
I think I'm on the list.
Well, the list
We're asked to,
doesn't say who's for or against.
it just says testify, so.
Right. Do you wish to testify in opposition or do you wish to be neutral?
Opposition.
Okay. Please use the dice.
For the record, my name is Mike Faust. My wife Karen and I, we've lived for over 12 or 11 years on Summer Park Association lot number 24. This is the property that is directly west of lot 25. We are here today to contest the staff's assessment regarding the proposed conditional use permit CU 26-04 for Summer Park Association lot 25. While the staff views the issues in the report as routine residential matters, the physical reality of the site and the history of its development proves that a commercial short-term rental use here creates an infringement on property rights and on it challenges public safety. The response in section G of the staff report, encroachment into private property, suggests that because trespassing isn't lawful, the city has no role in mitigating it through the conditional use permitting process. We disagree. It is the duty of the Site Planning Commission to ensure that a use is compatible with its environment, ensuring no adverse effects. The poor construction design acknowledged by the builder and the previous owner of lot 25 is not a hypothetical concern. The ill-conceived layout of the garage and the driveway area has forced us to build a costly boundary fence to help protect our private property. The physical geometry of the garage and the narrow driveway layout of lot 25 is fundamentally flawed. The slope of the land and the presence of a terrace wall drop-off, they create a pinch point. To navigate this access area safely, a driver's natural tendency is to swing wide. Because of the site's narrow constraints, swinging wide necessitates driving directly onto our private property. We accept the staff's legal stance on trespassing. However, planning is about risk mitigation. Replacing one knowledgeable permanent resident with dozens of unacquainted short-term rental guests exponentially increases the tendency for trespass. The city cannot ignore that the unauthorized use the staff report mentions will become a regular common occurrence due to the property's physical constraints. The approval of a commercial use short-term rental for a site with an access and exit design flaw demonstrates that the city is effectively sanctioning a site plan that encourages trespassing to function. The staff report notes that we retain the right to pursue enforcement. However, it is unreasonable to suggest that our only recourse is to post signs, call the police, or pursue litigation to protect our property. Do not consent to our land being used as a turnaround or maneuvering zone for the proposed commercial short-term rental. A conditional use permit should not be issued for a business that cannot contain its basic operations, including vehicle maneuvering within its own property lines. I have an exhibit that I'd like to put in as well. This helps to demonstrate some of our concerns. Moving to section H in the staff report, the safety risks of unacquainted drivers. The city planning staff characterizes high turnover traffic on our narrow curved slope private access roadway as a common and expected condition. We strongly disagree. The insertion that all drivers are responsible for safe operation is a deflection. The city's role in a land use hearing is to determine if the site's conditions are appropriate for their intended use. We contend that the intensity of a short-term rental use poses a safety concern on our private road. There's a fundamental difference between a permanent resident who navigates the challenging access road several hundred times a year and an unacquainted guest navigating for the first time, especially if it's at night or in bad weather. Long-term residents know the terrain and any associated blind spots. Short-term rental guests simply do not. The cumulative risk of a rotating door drivers who may be distracted by their GPS or looking for house numbers exceeds that of a permanent or long-term resident driver. So in summary, the staff report characterized our concerns as routine residential matters. Unfortunately, this generalization ignores the real physical complexities of the site. We contend that you cannot approve a commercial short-term rental use that practically necessitates trespassing for vehicular maneuvering. In addition, you cannot equate the navigation of a seasoned resident with the perpetual cycle of unfamiliar drivers on our challenging access road. We ask the commission to recognize that these are not merely common residential conditions. They are unique site constraints that make Summer Park Association Lot 25 unsuitable for a high turnover short-term rental. We urge you to deny this application. Before making a final decision, please conduct a formal site visit and commission a professional traffic safety and maneuvering study. Thank you for your time and consideration.
Mr. Faust, I'm looking at an aerial photograph of the property and it shows your fence. After you erected the fence, you still have trespass problems from vehicles accessing.
Yeah, it basically protects the property that's right behind the garage driveway area. But we couldn't extend the fence long enough because it would affect our access on our property. So essentially anyone who accesses that property, the tendency is to back up through the narrow driveway and swing off to the left to enter into our property. Or if someone is accessing it to back up into there, they drive up into our property and back up into the driveway garage area.
Do they have to do that to access that property?
Have to is not necessarily, no. but it is certainly,
But it happens.
it's certainly a very common thing.
Thank you.
Thank you for this opportunity. My name is Celeste Bonnickson. I am the president of the Summer Park Homeowners Association. So I'm speaking on behalf of the Homeowners Association today. Summer Park is a very unique homeowners association. We are less about the length of someone's grass and the appearance of their homes. We are more focused on our shared spaces within our community. That being primarily our park space, as well as the common access areas within our community that are shared by our homeowners. And I would like to state as a part of the letter that I submitted that I do believe that the Homeowners Association's opinions should have more weight in the process. I've been led to believe that our disputes are more of a civil matter. While I recognize that, we are a legal organization that was required as a part of the subdivision of the property by the city of Salem. And with the plat map that was established and approved by the city of Salem in 1997 and then filed with the county in 1998, with that became the requirements of our covenants, conditions, and requirements of our neighborhood. Within that, it is stated that commercial use of our properties is not allowable, as well as renting of rooms. So we do feel that this application is in direct opposition of our CC&Rs of our neighborhood. Now, that said, long-term rentals are allowed, and we respectfully request that you reconsider a long-term use rental for your property in lieu of the short-term rental. And then going to the park impacts. We do not feel that the impacts to our park and the neighborhood Little John Loop itself have been adequately addressed by the city in their staff report. And I don't know if you could pull up a map that shows more of the exterior of the entire neighborhood. Is that possible? Potentially.
Do you want us to pull up a map?
Maybe the city map that shows the lots, but the extended area that includes the Summer
do
Park Loop.
Yeah, I'm asking you if you want her to do that.
Yeah, I think it would be good.
Would it be good?
It
It
would
was,
easily do that.
You not have one on your slideshow?
it was one of,
I
what
have like the one that was shown.
yeah,
Maybe we can wait until staff.
I
okay.
don't know if she asked for it to be pulled up, so I'm asking you.
I would like to refer to it to demonstrate some of the traffic issues that we see within our neighborhood that I don't think have been adequately addressed based on the review of the lot itself. Because our neighborhood is centered around Summer Park that is literally in the center of Little John Loop. And in the staff report, it acknowledged how narrow that street is and that it does not meet city code. And so one of the things, and it's also a one-way loop. And so with that, the nature of long-term renters or residents that are familiar with the neighborhood know the traffic patterns. They understand that. Whereas with a short-term rental usage, they're not going to have that familiarity. And because we have a park literally in the center of our community, we have kids that are playing there, riding their bikes, riding their skateboards, that are out. And yes, there are parents supervising, monitoring, but there is a safety concern that we have for our community itself. And I would like that to be better addressed. Technically, my understanding is that the speed limit within that street is 25 miles an hour. And I will tell you that none of the residents that live there drive that speed. We typically are going about 10 to 15 miles an hour around our loop. And so I would also request a traffic study be done on more than just the immediate lot itself, but to consider the impacts on our community. And so I think that the report has been not sufficient in considering those impacts. And one of the things as well is that when you first pull into our neighborhood, the first street to the left is also part of Little John Loop. It is one way going out of the neighborhood. Thank you. Yeah. And we typically will see people that are unfamiliar with our neighborhood take a left on that one-way street that is against the flow of traffic. So it demonstrates the lack of familiarity that some drivers have in the neighborhood. While it does happen, we're concerned about that happening more regularly. So we do request there be a continuation of this hearing to keep comments open and consider this, or a denial based on insufficient impact or greater impacts to our neighborhood than what have been considered.
So are you requesting that the record be held open,
Yes,
a week? Is that-
yes.
Okay. Are we still gonna bring up the map?
Could we? I think it would help to demonstrate what we're talking about and my concerns for the traffic impacts.
Pretty sure. Yeah.
Thank you very much. And so you can see here from at the top of the subject property zoning map here, when you come into Hoodoo Court and then you take a right onto Storybook Lane, that street there is wider, but the Little John Loop, particularly when you have vehicle parking on one side of it, is extremely narrow. And that is a one-way street. So when you come in, the first turn of Little John Loop is actually the exit side of the one-way turn loop. And so you have to go straight and then take the second left to get to Little John Loop to then turn up into Lot 25. And then folks would need to actually turn right to exit Lot 25 to then leave the neighborhood and negotiate out of that. There is limited parking in our neighborhood, so most of our residents have cars that are parked on the street, and so it further narrows that area. And then in the center there is the park that is the center of our community. Most of our residents have moved to that community because of the park and wanting that privacy and that community and that safe space for our children to play and recreate. And we all look out for each other and each other's children and keep an eye on that. So we do feel that we have a very unique community that is not a typical residential community and HOA. As I said, it is less about the length of someone's grass and the appearance of their house. It's really to maintain this space and the oversight and safety of our community. Thank you very much.
Let me leave that up. Hello, my name is Jeff Parker. I live at 1121 Little John Loop, which is the adjoining home to the property to the east. I've been a resident there for 20 years. And I rise in opposition because there's unmitigated impacts from short-term rental to our property and the neighborhood in general. And I'll be referencing public comment number 3, figure 1, which you have on your desk, I believe. The site map that the applicant submitted doesn't show the transportation and utility easement. That is the upper easement, and when part of my commentary previously. And what I'd like to start out with is that the CC&Rs for the property condition in which we bought our house and the common areas and accesses work together. The one-way loop is narrow. It doesn't meet city standards. The private access road that goes to the 3 homes also does not meet city standards. And the characterization that people live, sleep, cook in the home is similar to long-term residents is accurate. However, the driver behavior of people who first come into this neighborhood, and particularly into the flag lot area, is completely different than somebody who's lived there for 20 years. And I would say that it's a steep drive and it has several flaws. And the first one is as you come up the access road, it's like, oh man, the green. But you come up this access road right here, the first 90-degree turn has no sight distance at all. So the long-term driver behavior from a resident is to come up to the top right here, pause to see if you're about to get hit. Or since these homes have children accessing the park, we don't have another way to get to the park. We have to walk down the road. And so if you come up at speed at 25 miles an hour on the private road, you are endangering pedestrians. And so what we have learned to do through decades of living there is that we come up and pause. At this point, that is knowledge that short-term rental folks will not have when they come up. It's a safety hazard. That second problem with the public access road, it's identified as a drive on their site map. It is not a drive. It's a private roadway. Difference is a drive services one home and a public or a private roadway services several. So the second problem that comes up here is when it's a flag lot with no cul-de-sac. A court in the city, a court with cul-de-sac is built to a city roadway standard. There's turnaround dimensions associated with that so people can navigate and turn around. The builder did not build this property with adequate hammerhead or single leg turnaround dimensions. So the only possible way for a small vehicle to turn around is to drive into their drive. And if we could, is it possible to pull up homeowner comment 3? Or not? Is it this? Okay, that's fine. You have it on your map. Anyway, in order for them to turn around without trespassing, they have to pull up onto their driveway pad in front of their garage, effectively. If it's encumbered with cars, they can't do that. Another item that isn't necessarily signed that exasperates the turnaround. And so what has happened since the construction of this home is that we have large number of vehicles backing down over 10% grade roadway across our property. It is a completely substandard road and would not be accepted as a public road by the city of Salem. Yet short-term rentals suggests that we would open it up for the general public. And so that's why I think it's a safety hazard and can't be mitigated by conditions.
At the start of your testimony, you seem to allude to the fact that there were previous short-term rentals in the area that caused problems. Is that true?
No, I
Or
didn't
are you
say
just
that.
talking generally?
No, I didn't. I was referring to that the staff has referred to short-term rental use as a typical use in a residential area. And what I'm saying is that this is a typical street that the CCRs were developed to prohibit commercial use and room rentals deliberately because those CCRs were used and thought of when the subdivision was designed and platted, including the flag lot road.
Thank you.
Yeah.
My name is Chad Cobbin. I live at 117 Little John Loop. And I'm in opposition of this for many reasons. To really break it down simply, to the right and left of this lot are people in the HOA. And when you go to buy a house, you sign HOA paperwork. So I'm really confused. Is this now not a part of the HOA? And the reality is if we have CC&Rs that are in place for as long as they have, and this community has been in existence for as long as it has. Does the city then come in and undo our CCRs? Does the city then come in and say that our HOA is invalid in a way?
They're not saying that.
Well, because that's what it feels like. Because if this goes through and this then becomes a commercial use property for short-term rental, what does that say for all HOAs? I think it sets a really big precedent, not just for this neighborhood, but multiple neighborhoods. And I mean, people came together to create this community. It was democratized. And we are a community that when we have long-term rentals that are being used, they're a part of our community and they respect that community. And they're not looked at as any different. But when we have short-term rentals, it's diametrically opposed to why this was created to begin with. The root intention of why this was created was about community and family, about having a common use area. And then to turn around and turn this into a short-term rental, it is diametrically opposed to the HOA that exists. So when we look at that precedent, what does that say for this city and other HOAs? That's the question that is a developing question. It's not conflict resolution practitioner. I look at this and there was no collaborative process. There was a posting of a hearing that wasn't posted where I could see it. But I think this set is a bigger issue, not just for this community. So I just want to state that. Thank you.
I'm James Weber. I'm the owner of 2747 Lower Breckenridge Loop, so I'm not part of the HOA or part of the Little John, even though I loop area. I'm a frequent runner. You maybe have seen me running your loop. And I run it, my family runs it, 4-5 times a week. So I can attest to everything the Little John community has said about the community and about the neighborhood and the children playing in it. I am directly kitty corner behind the property. So my concerns are predominantly with the conditions that this staff have presented and better defining those conditions. I do want to say, I believe you started, I think there was some confusion and something I wrote down too. The staff made a statement that I feel is incorrect. The staff made a statement that said, in essence, a short-term rental will operate as a single-family home. I believe that's what you referenced. I also disagree with that statement. I don't think a short-term rental is, in essence, I believe that's too vague. And so that's just, I disagree with that statement. Because it's not a single-family home. It's a short-term rental. It's a commercial property. There is a difference. I'll speak to the conditions. Everyone else was so I couldn't name them. I believe a condition that I have concerns with behind the property is light. So what happens when short-term rentals, they will have parties, they will have celebrations, it will occur. It's going to occur. What happens when they string lights up for Willamette grad celebration and it shines in my daughter's bedroom? What happens when it shines directly into our home? What happens when our privacy is invaded? These are the things that, I believe short-term rentals do lend hand to more than long-term rentals or single residents there, that we understand each other, understand neighborhoods, we can call them, we can chat with them, etc. Noise level, what does that mean? Say noise will stop at 10 p.m. Well, what's the decibel level then specifically? And who will enforce that? So who will enforce that when there is a noise violation? And one that is not stated, that I'll just say from personal experience and professional experience, is crime, break-ins, vandalism. I'm an assistant principal here in town. I work for McKay High School, McNary, Sprague, and now I work for CTEC, the Career Technical Education Center, as an administrator. I have gone through countless investigations in the Sprague and West community in particular, that our students, I'm sorry to say, they do know where there are vacant properties and where there are short-term rentals in this community. They do break in, they do party in them, and they do conduct illegal behaviors. So to take a community based like Little John Loop, that's based around family values, based around community at the center, and it turns commercial property, it will increase traffic flow as well as unregulated behavior from our community. I would also like to comment in support of my neighbors. As someone who spoke to Mr. Chin, who sold the property, who developed Little John Loop, when I moved into 2747, I spent a long time analyzing, purchasing that plot of land. I did not, because I spoke to many contractors saying that is a really challenging plot of land to build on. If you have not been out there, you need to go out there and really assess the drive, the easement, not only Little John Loop, the whole drive coming up, the drive coming around, going through multiple people's properties into then ending out at the house. The building of the garage is nuts. You step in the front step, it is an incline off their front step where how the builder did it. That is concrete like this. And then I don't know how anything other than maybe a Prius could actually pull into that driveway and pull out without hitting their fence. So I would ask the city, I believe you asked, would you like an extension or I forget the exact term. I would say, I don't think a week is enough. I think a traffic analysis is what we need, not a arbitrary extension of time, but an actual analysis to provide safety for the permanent residents there. Thank you.
Are there others who wish to testify in opposition? Are there those who wish to make comments but would rather not be identified as being in favor of or opposed to the application? Staff have any comments? Obviously, the deed for the property is in the record and contains the CC&Rs that have been referenced.
So the deed doesn't reference the CC&Rs, the deed references the plat and the lot number.
Okay,
The plat does reference the CC&Rs.
so where are the CC&Rs referenced?
They're, oh, sorry.
Go ahead.
They're in the CC&Rs themselves are in the record. They were submitted in the record. The plat references the CC&Rs.
I want to be able to read.
I have them if you would like to read them.
They're in the record.
They're in the record.
Okay.
No staff comments. It's an opportunity for summary. A request is made for the record to be held open. We'll talk about that. The applicant wishes to address any of the testimony that's been raised.
Sure, yeah.
Okay.
I'd love to.
So first I would love to address the condition of the driveway specifically. I did spend a significant amount of money clearing and creating visibility within that driveway as a part of this process. It's supposed to be a shared expense through the 3 lots. It was clearly not been being maintained for some time. So we did clear all the debris. We trimmed back all of the, there's some pretty significant bushes that go along that access road. We trimmed all of that back so you can see as you approach and as you drive up the driveway. We ourselves have not small vehicles, not a Prius. I have a full-size SUV that I pull into the driveway and backed out of the driveway. We have an F-250 truck, which we have also done it with. I do have similar concerns about that visibility at night that we've been talking about, ways to address that as well. Adding some, mirrors for that corner and some lights and reflectors along that driveway property. So I'm surprised that I didn't see any of that stuff, when we purchased this property going up to the road. It's, these guys claim that they've been there for, 10, 20 years. So, I want to invest in this neighborhood, and I think I've proven that so far. I'm happy to invest further in this neighborhood, even in the park that you guys so enjoy and that we thought was very cute. We live very close to this property in an HOA in a very tight knit neighborhood as well. So I understand, you know, where you guys are coming from. But this is not a cheap nightly rent property. It would be a very high rate. So we are looking at a very higher, you know, much higher caliber guests. We have a pretty extensive screening application that they go through. So, you know, we're doing, I think, above and beyond from our part to maintain a high, you know, level of clientele that we would see stay on the property. And I'm happy to answer, you know, any questions you guys have and any concerns you guys bring up. We are available. Yeah. Thank you.
Well, we have a request to keep the record. We're not going to require a transportation analysis by any means. One suggestion I did find useful, and that was for me to take a site view. And a lot of concern about access, driveway, visibility. And I think that's something the decision maker can't understand unless they've actually been out there and driven. So what I intend to do is to take a site view of the property and put my notes into the record and allow other people to respond to that. We talked about 1 week for comments. What we normally do is we have a week for comments, another week for people to respond to the comments that are put in the record, and then finally a week for the applicant to provide final rebuttal and summary, no new evidence, but address all of the comments that have come into the record the previous 2 weeks. Are there any objections to that? And my findings from my site view will be available within the first week for people to review. Any questions? So timeframes?
No, maybe I'll say that. So first set of comments are due by 5 p.m. April 15th to Caroline or the admin staff, and then the second response to those comments are due April 22nd by 5 p.m. And then the applicant final rebuttal is due by April 29th at 5 p.m.
Good. Thank you for your testimony, and hearing is closed.
Anyone would like one of my cards, my contact. Give it to you guys. I appreciate you guys. Sweet little boy, where are you going?
It's actually ironic, while driving here, I was listening to Spider Man's tear dog, that's my favorite, yeah. Okay, I was